Ladies and gentlemen, esteemed guests and distinguished speakers, good afternoon to everyone watching us online around the world. Welcome to the Space Resources Week 2024, where we gather to discuss the priorities, strengthen coordinated activities, and explore exciting new developments, enabling humanity to go further into space in a cleaner manner. My name is Dovile Matuleviciute. I'm Senior Manager leading Legal Affairs at the Luxembourg Space Agency. I'm also representing Luxembourg at the International Relations Committee of the European Space Agency, and I'm a delegate to the Committee on Peaceful Uses of Outer Space. Today, I'm particularly honored to devote 2 hours to the legal and regulatory session, diving into details and most important elements for the future international framework. As we embark on this session, it's crucial to recognize the growing significance of space resources and the pressing need for better national and international regulations to govern these activities. The utilization of space resources holds immense potential to drive scientific advancements, economic growth, and technological innovation. However, without adequate governance structures in place, there is a risk of conflict, environmental degradation, and other undesirable outcomes. We are privileged today to be joined by a lineup of esteemed speakers who are renowned experts in the field. Their insights and expertise will undoubtedly enrich our understanding and guide us towards crafting an international framework that fosters collaboration, innovation, and responsible use of resources. We will examine existing contributions, discuss the challenges ahead, and identify key considerations for states as they design and implement these frameworks. Your contributions are invaluable as we navigate these complex issues of space law and policy. So we encourage active participation through the chat function, where you can pose your questions and share your thoughts. We will try to reply to them at the end of the session if the time permits. We will start the session with Mr. Andrew Cannon, who is joining us online. Mr. Cannon is former senior mining at Warden and Deputy Chief Magistrate, adjunct professor at Adelaide and Flinders University, and visiting professor at Münster University, Germany. He will talk today about the necessary extension of the rule of law to space mining. Mr. Cannon, you have the floor.
Thank you. I'm not sure I have my slides on screen yet, but I will go ahead anyway. So there's a lot of experience on Earth, in nation states, and how to manage mining in a way that is responsible and works well. And I can tell you that if you have a good-looking deposit that you think is worth mining, and you go looking for money for it, and of course insurance, the people you approach will ask 3 questions. Have you got secure title over the resource? That's secure against any other comers. Have you got regulatory approval? Because we want to be sure that you're doing this in a responsible way. You're not going to make a mess. You're not going to cause discredit and disruption by bad practice. So we want to make sure you're well regulated and you have the approval of the regulator. And have you come to an agreement with the local landowners? Investors in space mining are going to ask the same questions. And if the answer to any of those questions is no, you won't get your money. Next slide, please. So let's look at those questions individually. The first one is, have you got secure title over the resource? Miners need clear rights. First of all, to have a look whether there's anything worth mining there, anything valuable. And once they find something valuable from that exploration, well, then they need to evaluate it to see how hard it is to dig it out, and what the market is. Do they need to refine it at all? So they need to evaluate it. And then they need, if all that works and they do start mining, they need the exclusive right to mine, and they need clear title in the resource to sell it. Now, the Outer Space Treaty of 1967, which prohibits nation-state sovereignty, makes establishing these rights difficult, uncertain, and I won't go into the academic discussion about that, but there's clear difficulties in having clear title. And the idea that you can just do it by self-regulation of a community is okay while your community is cohesive. But when you get a bad actor comes on the scene and ignores your community agreements, then everything doesn't work. There was an example of that back in the early 1900s in the Arctic island of Svalbard or Spitsbergen, where there were coal miners and other miners there, and they were working away in a community without conflict, and then some bad actors came in and there was conflict, and eventually they resolved all that by providing a treaty which gave nation-state status over Spitsbergen to Norway, and Norway respected the rights of the existing miners. So in space, it'll be the same. Community title won't work. And the Risk and Compliance Department of Investors and Insurers won't accept any title uncertainty. They're not going to rely on community title as sufficient. On Earth, you get title to resources by the payment of fees, by regulatory compliance, and by the payment of royalty when you mine the resource. Now, next slide, please. Now, mining can be messy. That's why you need regulatory approval. That's a picture of the Rio Tinto river in Spain, no reflection on the company of the same name. And terrestrial miners need to establish a social license, and space miners will need to do the same. You need to have an environmental impact assessment to provide for safe mining, and you need to have that approved by someone, and you need to have a rehabilitation plan to deal with the consequences of mining, and that's all got to be approved by a regulator. And the third question was, have you come to an agreement with the local landowners? Well, people say there's no landowners in space, but there is a sensible group of people who assert that there should be a common heritage of mankind. And there's no doubt that if you do go ahead with mining without coming to an arrangement that satisfies those interests, some of them will sue. They'll find a court somewhere, they'll find a lawyer somewhere, and they'll sue, and that'll just provide more uncertainty. And the Risk and Compliance Department of the financiers and the insurers will not accept that uncertainty and the risk of being sued, and only a new treaty will put in place a clear regulatory regime that is needed for mining in outer space. So, next slide, please. What might a new treaty look like? First of all, I'd make the point that in situ resource utilisation by a space base, that doesn't really fit within commercial mining. It's the same as on Earth here when you have a landowner who wants to dig up some gravel, dig up some sand, make some concrete with it. They don't need to get a mining license for that. And it'll be the same in space for Israel, but not when they start purchasing them from someone else, because the vendor of them is a miner for profit, and you've created a market, and as soon as you create a market, you will create a rush to satisfy the market, and you need to regulate that. You need to regulate that now, not after the event, because bad risk-taking actors will come in and they'll make a mess and cause conflict. I think we should accept in a treaty regime nation-state management of the regulation of their miners, but under an agreed international supervision and agreed internationally agreed standards. but the actual day-to-day regulation should be done by nation states rather than try and set up an international regulator. And that will necessitate then mutual recognition of rights granted by each nation state on a first-come, first-served basis with a registration system internationally. Explorers will need to purchase some time-limited exploration and evaluation rights by the payment of registration fees and by regulatory compliance, just as happens on Earth with terrestrial mining. And then when we get to the stage of actually mining, miners will purchase the title to their recovered resource by the payment of royalty. Now, that'll be controversial. Firstly, there's two types of royalty. There's royalty on production, and royalty on production acts as an impediment to investment because you're front-loading the expense on the first bit of ore that is mined. Or you can do royalty on profit. But having no royalty, the consequence of that, if you think about it, is that all the taxation benefit from the profits of mining in space will end up in the rich country which financed which the company came from that did the mining. And so if all the tax profit is going to the rich country, I don't think that's going to fly internationally. So you'll need to have royalty, and royalty is a much cheaper way of achieving certainty and than having uncertainty, because uncertainty, the premium that you'll have on your finance, will be much more expensive than the cost of the royalty. And then finally, a key thing, speaking as a retired judge, is that you will need to have a good court system. One that's quick and efficient and knows the mining trade, just as we do on terrestrial Earth. And if you've got a time-limited opportunity to go and see an asteroid and take something off it or something else, you don't want to wait for 18 months while an international court sorts out a dispute for you. You want a quick result. And so you'll need a specialist court to deal with disputes promptly, but also to enforce compliance with the international standards that'll be necessary to underpin this system. So that's a brief sketch of all that. Next slide, please. There's a few other issues. I don't want to overextend my time, so I won't discuss these in detail. I just identify them. Is solar energy a space resource? It's going to take a lot of acreage, so might be considered as such. And how do you map the areas and volumes for exploration of mining rights in the various space objects that might be subject to them? I think we need standard technology so that there's compatibility of equipment, so that if some equipment has to be left, someone else can buy it, use it, and it's not just junk. And what are the criteria for an environmental impact assessment in space? It's an interesting question. And the same similar question applies to what does rehabilitation look like and what standards do you need to impose? We need to establish, I suggest, a remediation fund to fix up accidents. There will be accidents. What we do on Earth is that we take a small portion of the royalties and we put them aside in an interest earning fund, and then that is available to fix up accidents, and you can recoup the money later from the bad actor unless they're bankrupt and the nation state that authorised them. But that all takes time. If you've got an accident, you might want to have the money on hand straight away to fix it. What are the criteria to distribute the royalty to the rest of the world? That'll be a rich topic of conversation. And we need a communication strategy to convince the people of the world that this is all a good idea. And so I have submitted a paper with the conference, and attached to that paper is some suggestions on what a treaty might look like in much more detail than I've tried to cover today. I don't suggest that my suggestions are not the end product. They're merely submitted to try and get discussion moving, because as I hope I've convinced you, there will need to be a treaty. Thank you. Next slide. That's it.
Thank you, Andrew, for your wonderful presentation. I have a question for you. I was wondering, who would collect those royalties? Do you see some kind of additional body doing that?
I see there being an international oversight body which will provide standards for the nation-state supervision, and also will be the registry for the treaty, the mining rights that are granted, and also will collect royalty and distribute it, and do other functions, no doubt.
Thank you, Andrew. So when in 2016 until 2019, we worked with the Hague Working Group on space resources activities, and we produced 20 building blocks. We also thought about the benefit sharing. And at that specific building block on benefit sharing, we recognized that for states, it's extremely important to have access to cooperative activities, participate in scientific research, find research opportunities. And there was also an idea of setting up a specific fund. Like just the first idea, we didn't develop further on a specific investment fund. And we also recognized in the building blocks that sharing monetary benefits is probably not the most important thing. It's a possibility, but not the ultimate goal. So there are different approaches with regard to the benefit sharing and the monetary benefits. So thank you, Andrew, for your wonderful presentation. I will move now to our next speaker, Niklas Hedman, Vice Chair of COSPAR. And Niklas will talk today about COSPAR Planetary Protection Policy for Sustainable and Scientific Space Exploration and Utilization. The floor is yours.
Thank you, Dovile. And thank you for inviting me to this panel. As Dovile said, yes, indeed, I represent the Committee on Space Research, COSPAR Panel on Planetary Protection. I have a short presentation here with a lot of text, and you will find it confusing if you read it now. So you can listen to me and you can read the presentation later, because there is a lot of information in there. COSPAR is a non-governmental entity, non-governmental organization worldwide, and it was founded in 1958, mainly as an organization or a platform where scientists, space research scientists from the United States and the Soviet Union at that time could get together and share information and experiences. And the organization has obviously grown over these past nearly 70 years. The organization works with commissions and various panels dealing with more or less all aspects of scientific research of the outer space environment, including the moon and other celestial bodies. And what I will focus on today is one of those panels, labeled the Panel on Planetary Protection. So before going into some of the legalities, and particularly the relationship between planetary protection standards and the Outer Space Treaty, we have to establish, first of all, what is planetary protection. And in a nutshell, it is really two messages. The conduct of scientific investigations of possible extraterrestrial life forms, precursors, and remnants must not be jeopardized. And in addition, the Earth must be protected from the potential hazard posed by extraterrestrial matter carried by a spacecraft returning from an interplanetary mission. it is basically the search for the origin of life in our solar system. That is what the scientific community is concerned with when it comes to setting up the standards for planetary protection. And what I read out here, and you see it in the middle of that slide, is what we label forward contamination and backward contamination. And it's really the scientific investigations at focus. So the planetary protection standards that this panel I'm representing has developed over decades, the policy on planetary protection, is not an environmental instrument. So it's not the concern of environments of the planets and other objects, celestial objects in the universe, or I would say in the solar system. It is our own scientific investigation of those environments. So the policy is a voluntary, non-legally binding instrument, and it really, I would say, provides recommendations and guidance to spacefaring nations when they are conducting missions to the moon and other celestial bodies. And it's obviously up to the respective nations to regulate how those missions are to be carried out and what impacts it could have if they return with samples, etc., from those planets back to the biosphere of planet Earth. And it's really the scientific judgment of those respective states that is at stake here. And obviously, national regulatory agencies has the responsibility at the national level to foresee that there wouldn't be any, I would say, an issue with the responsibility of the government in question vis-à-vis the treaty regime laid down in the Outer Space Treaty. So the panel itself, through this policy, is providing a guidance for states to comply, particularly with Article 9 of the Outer Space Treaty. And I will address Article 9 a little bit more in detail. First of all, before doing that, in the policy, obviously it's a scientific instrument, and it has evolved over decades. Planetary protection started already with the first missions way back in the 60s. And along the line in the scientific community, where more information is gathered, when the scientific knowledge of our celestial bodies in the solar system has grown, of course, there is a need to update and refine the policy further. What you see on this slide, and remember now what I said, there is a lot of text in my slides, so you can read it later. But what I want to illustrate here is the categorization of the objects in our solar system. Not all objects, not all celestial bodies are actually today within those categories, because there is more and more information coming all the time. But the basic element here is that from category 1 to category 4, it means that category 1, there are no planetary protection concerns, while category 4 is really where you need very robust sterilization and containment and clean room standards, etc. You need really to be careful, because there might be biological life out there. Particularly what we are looking at now is obviously the outer solar system objects. So the planets of the outer solar system and their respective moons. And the two moons that are really at focus is Jupiter's moon Europa and Saturnus' moon Enceladus. And because those bodies are confined of ice crust, and below this ice there is water. And we don't know how big those water deposits are, but if there is water, there might be life. So again, the whole concept here is about the search of the origin of life, and whether there is life or whether there has been life in the solar system. And that is also why planet Mars is quite important for the scientific community. So that is for the forward contamination. Backward contamination is targeted in category 5. You have to be very careful when you bring samples back to planet Earth, because there might be something that could be an extraterrestrial material of a biologic nature that might come into the biosphere of Earth. So that is why this is really a concern in the scientific community. So that, so far, so good on the scientific side. Now we will dig a little bit deeper into the legal side. The basis for planetary protection is the Outer Space Treaty adopted in 1967. And on this slide, I have just captured, so you can see the various principles, the core principles of the treaty. And as we know, it's a treaty of principles. It's very general. The articles, respective articles, are not that detailed. Many terminologies used in the Outer Space Treaty are not defined. Harmful contamination, which I'm talking about today, is not defined in the treaty. And there are, of course, obviously, different interpretation among states on what those terms mean. You also have to see the Outer Space Treaty as a whole, because the various provisions are interconnected. For the purpose of planetary protection, there are two main articles that are really crucial. The first one is obviously, as I already alluded to, Article 9, which deals with mutual assistance, due regard, harmful contamination, and harmful interference. Wow. That is the longest and most complicated provision in the entire treaty. And that is the basis for planetary protection, forward contamination and backward contamination. Article 6, international responsibility for national activities in outer space, is fundamental in the area of planetary protection, because all missions, and in the past we have seen several missions, and now we know that there are a number of missions that are being planned to the moon, obviously, and also to Mars and to the outer solar system. And it's up to the national legislator, the regulatory authorities at the national level, to implement the rights and obligations under the Outer Space Treaty. But they can be held accountable in the sense that they are responsible for national activities carried out by non-governmental entities, meaning private and commercial actors. So these two articles are the fundamentals for planetary protection. And you can see the text or parts of the text, the essence in those two, I have actually put, yes, Article 9 and Article 6. So this element that is highlighted there in Article 9, to avoid the harmful contamination and also adverse changes in the environment of the Earth resulting from the introduction of extraterrestrial matter, is really what I'm talking about here: forward contamination and backward contamination. Article 9, as I said, very complex, because you have to see it as a whole, and there is actually a relationship between the various components of Article 9, due regard, harmful contamination, and harmful interference. I'm not going to go too much into detail about Article 9, because then we can discuss this for 2 hours and more, but the element there in the middle is interesting, because when member states of the United Nations adopted the Declaration on Legal Principles way back in 1963, which serves as the precursor to the Outer Space Treaty, which was adopted in 1967, so only some years later, that resolution contained already more or less what we see in Article 9 today, except harmful contamination. So harmful interference and due regard, etc., were already there in that resolution. But in those coming years, after 1963 to 1966, when the deliberations of the Outer Space Treaty ended, harmful contamination was included in this mix in Article 9. And one of the reasons why harmful contamination actually got into the treaty itself is thanks to COSPAR. COSPAR had a very important role at that time and provided a lot of scientific information and background to the deliberations by member states at the Committee on the Peaceful Uses of Outer Space. So it was a very active scientific community underpinning the political deliberations that resulted in the Outer Space Treaty. So since then, there are also reaffirmations made by COPUS in the terms of how important it is to look into scientific research of our solar system to search for the origin of life. So COPUS has made a few such acknowledgements. From 2017 is one, and also in the 2019 guidelines for the long-term sustainability of outer space activities, as we know as the LTS guidelines, that you can see on this slide. Very briefly, the panel consists of members of space agencies, so representatives of national space agencies of major spacefaring nations, as you can see on this slide, and also independent scientists in various disciplines that really are relevant for the search of life and which is concerned with planetary protection. So this is the current membership of the panel. Recently, in 2021, we made the latest update to the policy where we relaxed the guidelines or requirements for the moon. So for the moon as a whole, it's documentation requirements. So that is the only that you should provide some documentation of your missions and what you bring to your mission to the moon. When it comes to landers, but we really had to look into this very carefully, and for that reason, most part of the moon is only the organic, I would say, inventory needed for what we bring within the propulsion systems. But for the polar regions and the permanently shadowed regions, there we really thought that we need to stick to the full organic inventory. So this is in a way a modernization of the policy. And we are looking now, obviously, into various both robotic and in the future human missions to Mars, but we are also looking quite carefully into the outer solar system bodies, icy worlds, I already mentioned, and Europa and Enceladus, which are already targeted by the policy that we have developed in this panel, but we are now looking also into furthermore of the bodies in the outer solar system. So this is a continuous work going on. And lastly, in a couple of weeks, we will have our first Planetary Protection Panel Week in London, hosted by the UK Space Agency and the Open University, which will bring the scientific community together, discussing all those matters. Thank you.
Thank you, Niklas, for very informative presentation of COSPAR work. Our next speaker is Mr. Dorin Prunariu, a former astronaut and also a chairman of the Global Expert Group on Sustainable Lunar Activities, GEXLA. Dorin will speak about cooperation and coordination issues related to operational approach to lunar activities.
So I'm sorry I'm not present there, but I tried to make the presentation from far away from Bucharest. I hope your software for changing the slides is working. So I will speak about cooperation and coordination issues related to operational approach to lunar activities. We already witnessed, we already witnessed a multitude of lunar missions through the effort of both space agencies and commercial stakeholders. There are many mechanisms for cooperation for lunar and cislunar activities, but no dedicated forum for this work in the United Nations Committee on the Peaceful Uses of Outer Space, since the committee is the only forum in the United Nations system that it's specifically designed to foster international cooperation and build consensus to advance the peaceful exploration and use of outer space for the benefit of all humankind. The need to preserve the peaceful uses of outer space, together with the desire to begin a new era of sustainable space exploration, urges increased discussions, coordination, and cooperation for cislunar and lunar activities. A number of issues must be addressed to ensure sustainable lunar exploration and settlement in and around the moon, including for lunar operators to share information on their ongoing and planned operations, and to engage in consultations in order to coordinate operations, facilitate interoperability, improve safety, avoiding interference, protecting the lunar environment, mitigating the creation of debris in lunar orbit, regulating access to natural resources, sharing best practices and lessons learned, and building capabilities, identifying common needs and concerns of lunar operators. As you already know, the Global Expert Group on Sustainable Lunar Activities, GEXLA, organized by the Moon Village Association, an observer to UN COPWAS, representing a neutral forum for multi-stakeholder discussions on lunar exploration, with a goal of de-risking future lunar missions and increasing global cooperation for lunar exploration and settlement, published a report named Recommended Framework and Key Elements for Peaceful and Sustainable Lunar Activities. The work of GEXLA. The work of GEXLA inspired the Romanian delegation that met last February at STS COPWAS the proposal to organize an action team to study a potential consultative mechanism on lunar activities within the framework of UN COPWAS. Such mechanism, once approved, will bring a concrete coordination of operational lunar activities. For example, landing coordination, debris mitigation, cislunar traffic, protection of sites of scientific interest, and lunar heritage. This activity is made by the lunar stakeholders, and it would actively involve UN COPWAS countries in a major theme for space cooperation in the next decades, from which it cannot remain absent. Some reflections on its functions regarding the cooperation and coordination issues related to operational approach to lunar activities are presented below. Cooperation and coordination broadly encompass all decision-making and management related to the full range of lunar activities, which, throughout multi-stakeholders engagement and dynamic interactive processes, supports sustainable exploration and use of the moon. At the same time, cooperation and coordination address shared challenges and expectations related to the use and exploration of the moon in order to ensure peace and security thereon, maintaining sustainability and benefit all humankind. Cooperation and coordination on the moon will be guided by the wide range of hard and soft law instruments and requires a complex and adaptive framework. This, in my view, seeks to respect general principles and norms, such as those enshrined in international space law and soft law instruments, including but not limited to peaceful uses, due regard, non-interference, mutual understanding, non-discrimination, equal access, freedom of exploration, non-appropriation, information sharing and transparency, having an international character. Ensure predictability, accountability, coherence, and synergy in a manner that fosters mutual understanding, including fair access and market competition among multi-stakeholders in lunar activities, and align governmental, intergovernmental, and non-governmental actors through an adaptive process, including public-private partnership, private funding initiatives, and the application of innovative technologies. Lunar stakeholders should strive to operationalize this multilaterally agreed upon framework with a focus on the protection and management of the lunar environment and sustainable lunar activities. This process should include the meaningful involvement of stakeholders from developing countries. Cooperation and coordination are integral part of the lunar governance that should be considered within and contribute to global space governance, including the Space 2030 agenda and the guidelines for long-term sustainability of outer space activities as a pioneering project for deep space governance. When we speak about space resources, first of all, we have in mind natural resources of a celestial body, in particular of the moon, which could be used in situ for producing water and oxygen, energy from sunlight, construction materials, habitats with protection against natural hazards like space radiation and meteorites, and other type of infrastructure necessary for the human activity on the moon, but also very valuable minerals and compounds which can be produced initially in situ and then transported and used on Earth in favorable economical conditions. Even the use of the location and physical properties of the moon represents a space resource. The time horizon for the start of commercial activities related to space resources, it's about, in my appreciations, 10 years, and this will provide time to agree a legal framework to regulate these activities as it's presently planned by the working group on legal aspects of space research activities under the legal subcommittee of COPS. In my view, important topics to be discussed and agreed upon in the frame of Space Resources Working Group to obtain the support of all countries are the benefits sharing and sustainability of the extraction. The benefits sharing is key to ensure that not only the major stakeholders with actual lunar programs will have benefits from using space resources, but all the humanity as is required by the Outer Space Treaty. Furthermore, in line with the Agenda 2030 and the Summit of the Future, lunar resources should be used as much as feasible in a sustainable manner in order to continue lunar exploration for the benefits of the future generations. As I said in the beginning of my presentation, we need a coordination of the lunar activities at the level of UN COPUOS to avoid possible conflicts, and this can be done by a consultative mechanism looking mainly to the operational aspects, reporting to the committee, involving not only state actors, but also non-state actors developing lunar and cislunar activities. The working group on space resources is focusing on lex ferenda, since these activities will take place not only, but in a few years. Thank you for your attention.
So thank you, Dorin, for your wonderful presentation. Our next speaker is Donna Lawler, principal at Azimuth Advisory, and Donna will talk about the wisdom of First Nation peoples. Very unique presentation, so looking forward to it. Donna, the floor is yours.
Thank you, Dovile. Thank you so much for having me. And I'm going to start out with an apology because at the end of this 15 minutes, you are not going to know very much about the wisdom of First Nations people. And that is because firstly, 15 minutes is not nearly enough time to convey, in the case of my country, Australia, 65,000 years of continuous culture of astronomy and knowledge about the connection between space and Earth, but also because I am not Indigenous and I do not speak on behalf of First Nations people. Instead, incongruously, I am an Australian commercial space lawyer. I have spent 25 years conducting about $10 billion worth of space business. And my only expertise, really, in speaking about this topic is that I have been in discussions in Australia with some unbelievably wise Aboriginal elders. And in the course of those discussions, I have gained a tiny glimpse of the depth of knowledge that they hold about the heavens and about the connection of the heavens with the earth. And I became aware of how little I understand and how much I have to learn. So I want to convey that to you today, and we'll see where we get. This is a picture of the Cagnini spacecraft, which is being built in South Australia. It will be launched later this year. The satellite's name is Cagnini is a Pitjantjatjara word, which in the local people in that area in Australia, in their language, it means responsibility and unconditional love for all of creation. It is an enormous caring with no limit. It has no time frame and is eternal. So it's a beautiful merging of Western science with some quite profound Indigenous wisdom there just from the get-go. This is a slide provided to me by Professor Dean Sanders. He is a lead partner at Deloitte for integrity, ethics and the future. He is also a senior initiated Aboriginal elder from the Worimi people in New South Wales. And he asked me to show this slide, reminding me that wherever we are in the world, including in Luxembourg, is what Aboriginal people would call country, and an Indigenous place. Even if they are no longer able to speak for it, the country still remembers them, is something that Dean reminded me. So in Australia, it is customary to include an acknowledgement of country at the outset of any event. In other places in the world, they call these land acknowledgements. But as Dean pointed out, everywhere is mother. So I want to acknowledge the original people who inhabited this place, whoever they may be, and I pay my respects to all Indigenous people who may be here today. Okay, in May 2022, this is really part of my own journey as to what led me to be speaking about this topic. Space leaders from across Australia gathered in New South Wales near a place called Yengo, a sacred mountain, to accept responsibility and to declare a role for Australia as a custodian nation for space. And forgive me if I stick a little closely to some of the language here, because I have been given permission to talk about some of these matters by the Aboriginal elders who were there, and so I need to be a little bit careful about the words they have authorised me to say. But the weekend that we spent was a stunning weekend spent what they would call on country, and they talk about land country, sea country and sky country, which is outer space. We were camping on the land together with Aboriginal elders. We had the head of the Australian Space Agency, the chair of the Australian Space Agency, astronomers, academics and representatives of industry there. It was quite a small group. Over that weekend, I was absolutely shocked and delighted by the complexity and the depth of the wisdom. And I was particularly delighted in being confounded every 5 minutes by something completely different that I had never thought of. And, you know, I'm a little bit of an intellectually arrogant person. I think I'm very clever. And so whenever I thought I'd understood something, I would do what lawyers tend to do, is repeat back and go, so it's like this, is it? And the elders would shake their heads and say, mara, no, it's the opposite of that. And I can't tell you the delight in just being so wrong so often, but because it just expands your mind into a new paradigm. An example, well, maybe I'll just keep on going with some of these things. Australia is home to the planet's oldest continuous culture, which holds custodial responsibility for the system of Earth and stars that make up the universe. So 65,000 year plus continuous culture, it's unique in the world. By custodial responsibility, interestingly, they don't say they own the stars or the moon or outer space. They are custodians of it, and they are inviting us to share the responsibility, that custodial responsibility. First Nations people hold the knowledge and the leadership to connect the long humanity of this planet to our shared future in the stars. They are not against space exploration, but they have wisdom that they wish to share with us. By bringing that ancient knowledge, culture, and systems of law together with the world's most adaptive and entrepreneurial community, many of you are in the room today, Australian Aboriginal people at that gathering declared their intention to take all of humanity to space. So it's an ambitious declaration that they made. And I'm really only talking about Australian First Nations people, but I know that there are many concepts in common with First Nations people in other places, including in Native Americans in the United States and other places. Taking these opportunities, so we're here to talk about space resources, these are opportunities we want to take, will require all of us, that means all of us, all of you, to accept responsibility and require that we each, as individuals, act as leaders. So I'm conveying these things to you because as they were conveyed to me. You might have heard something about the some of the different ways Aboriginal people see outer space, and you may have heard, I know Melissa, you've heard about the dark emu, a constellation which is made up not of little dots of stars with little lines drawing them, connecting to make a cute picture the way we see constellations. Rather, it is an enormous dark space in the Milky Way, and if you actually see it for real, it takes up 3/4 of the sky. It's absolutely massive, and it's a lovely illustration actually about how we see the world one way. We see constellations and little lines on the outside, and First Nations people are looking at the spaces in between and the connectedness, and it's an illustration to me of how they think so differently. Another example of how, this is just a tiny example of just how I was confounded by different ways of seeing things is we were shown some carvings of an emu on the ground. An emu is like a giant ostrich, as you can see. And you can see an example of a carving on the ground. And some of these carvings are used in Aboriginal culture to show, for example, where the hunting grounds are. And so when I said to the elder who was showing me, I'm pointing to where the beak is pointing, so the hunting grounds are over there? And he said, no, over there. The feet, it's the feet. The feet are pointing because that's where the tracks are. Anyway, just another example of how everything I tried to understand was the opposite of what it actually was, how much I had to learn. But this constellation is actually used in many Aboriginal communities for determining where and when to hunt emu, to find eggs, and when they're hatching, that sort of thing. So it's ancient knowledge. Okay, and another example, and this is really, I'm just trying to give you illustrations of how wisdom can come across and can be surprising. Imagine you are an engineer. Do we have any engineers here? Might be one or two. Imagine if you are an engineer in Australia and you've been asked to find water in a desert. Where is the groundwater? How is it all connected up? This was the task that over the last couple of 100 years, water engineers in Australia have set themselves. And to be honest, they're still a long way from finding out where all the water is, how it all connects. It's all a bit of a mystery. Right from the get-go, Aboriginal people, when Australians would, engineers would, or colonial engineers would go out looking for water in the desert, Aboriginal people would say something like, well, when you're out there, you watch out for that two-headed snake. And they'd go, yeah, thanks. And then they'd give them a painting that might look something like this. Watch out for the two-headed snake. And they'd go, thank you. Don't really know why you gave me that. Anyway, we're going to take our scientific measurements now. Goodbye. Did they listen? No, of course they did not. It's only a couple of 100 years later that we're starting to realise that some of these artworks, like the one that you can see here, are absolutely precise depictions of groundwater. They are waterholes, they are the connections. It's mapping an entire desert as if it were a hyperspectral image from space. It's showing invisible water, the depth of it, the nature of it, what needs to be done to look after it. And it was ignored for centuries in Australia, and only now are they realising, oh, we should have listened to them. Similarly, you'll be aware that in 2019, pretty much a lot of Australia actually burned to a crisp. Millions of animals died. At our peril, we have ignored Aboriginal people in the way that we manage our land, the way that they have managed for 65,000 years land and with ritual, cultural burning has made their enable them to live sustainably on the land for 65,000 years or more. So why should we listen to Indigenous people? Well, in the case of Australia, what would they know about sustainability having lived in such a place without destroying the joint in 65,000 years when we've been there for 200 and we have pretty much trashed the place? I am running out of time, I know, but I will just allude to the situation that happened in the United States with the Navajo people and the peregrine lander, the sending of human remains to the moon, which was contrary to a promise by NASA to consult the Navajo people before sending remains again. They did not consult, and it's caused a major furor. I won't go into that because I am running out of time, but it won't be news to you that this happened, and NASA has had to agree again to do better when it comes to consultation. So some principles to consider. I will just go through, once again, I'm paraphrasing, but these were some of the principles that came out of that amazing weekend that we spent with Aboriginal leaders. There are 5 of them here that I'll go through. Number 1, space leaders, that is you, should acknowledge the custodial role of Indigenous peoples for space, privilege the voices of Indigenous peoples, and respect Indigenous intellectual property rights, cultures, knowledge systems, and traditional practices. I would go further and say we should be sharing that custodial responsibility because we are also custodians. We should be resisting the obscuring of the night sky, which is an interference of the human relationship with space. Respect for traditional knowledge and culture must inform processes and decisions about space, humanity and the environment, and should underpin the ethical and legal frameworks for how governments and corporations access and use space. Fourthly, governments and commercial participants, there's a few of those in the room today, have a duty to land, sea and space, including respecting the cultural heritage of Indigenous peoples. And lastly, but not leastly, prioritisation of system-wide health and opportunity for Indigenous people should be a part and parcel of our activities in space. And these 5 principles form the basis of some protocols which Australian industry has been urged to adopt as part of all space activities. So lastly, this is the question that Dovile asked each of us to answer. From your perspective, which element would you propose the states to consider when designing future international framework for space resources activities? It's a really excellent question. Well, I'm going to pass on some wisdom that has been passed to me from Australian and Aboriginal people who urge us to consider what they call the next 7 again in every decision, which is a foundational concept in their culture. Anytime they take a decision, they are urged to consider the next 7 generations, not just themselves, not just their own job, but for the next 7 generations. And interestingly, I'm sure you could do a survey of the whole world and you'd find more than just 2, but in the United States, the concept of 7 generations with Native Americans comes up very often as well. Here's one example. In every deliberation, we must consider the impact on the 7th generation, even if it requires having skin as thick as the bark of a pine. And I'll leave it there. I know this is just a very tiny, tiny taster, but I would just give you all the challenge. Can we share this responsibility to be custodians in space for the interconnectedness of space and the Earth and all things?
Thank you, Donna. Wonderful presentation, very unique, so much food for thought. So I hope that we can hear those very unique positions, not only in the events like this one, but also at the UN COPUS and other more international forums. Our next speaker is Güneş Ünüvar, postdoctoral researcher, Luxembourg Center for European Law. And Güneş will talk today about regulating outer space as environment. The floor is yours.
Thank you, Dovile. And also for full disclosure, I am a researcher, primarily an academic, but I do wear multiple hats, one of which is I'm a counsel on space law in a Luxembourg-based law firm, Wood. Also the legal advisor for the Moon Village Association, so there are multiple parallel, very harmonious hats, but today I'm here on behalf of myself as a researcher. So after Donna's extremely insightful presentation, mine might seem a bit bland, but I'm going to do my best to make it as interesting as possible. So one of the research projects that I'm pursuing at the university concerns outer space and regulation of outer space, its intersection with private activities in outer space, not exclusively but primarily. And one, let's say, sub-segment of this research focuses on regulating outer space as environments. Now, this is a very loaded word, environments, and the moment I utter this word, depending who you are, what your profession is, a different reiteration of the concept will pop up into your mind. This is exactly the sort of lead that I wanted to embrace in this research and explore what kinds of different productions of environment we can talk about and how can we position the concept of environment discursively in the way that we approach, we think about outer space regulation. Now, being a lawyer trained in the most black letter law ways, of course, it wasn't enough that I only looked into law. I had to expand somewhat insecurely my horizon and look into social sciences. So it very pleasantly turned into somewhat interdisciplinary research. So I benefited quite a lot from environmental sociology. In particular, one research spoke to me by Professor James Ormerod at the University of Bristol. He's a sociologist, but does extensive research in environmental sociology and does so in the context of outer space. So he has this paper in particular where he does not speak about regulation at all, by the way. It's a very philosophical, very sociologically minded, very broad, very insightful paper. And as I was reading it, and as I was reading different segments and different productions of environment he speaks of, I thought, the lawyer in me at least said, okay, actually he's giving us a very useful categorization of outer space regulation. And he's doing so in the context of environment. So I turned it around its head and tried to conceptualize his productions as ways to look at environment as a regulatory discursive tool. So that's what I'm going to do here today. I'm going to, one by one, introduce his productions, the way that he named them, and qualify them a little bit, as lawyers do. So the first, and the three of them, the abundant environment, risk environment, and wilderness environments, and the fourth one that I've added as, let's say, a further contribution as space as research environments. And I'm going to detail them as much as possible. So the first one is looking at outer space as an abundant environment. So what do we mean by that? It's actually the very raison d'etre why we're here today. We're talking about the alleged abundance in outer space of resources. Right? These obviously can be material resources as they can be found on celestial objects. I assume you're all interested in this particular subject. And the environment's overall general potential to be used to further our use and exploration, and more controversially, exploitation of outer space, right? So the assumption is that there's an abundance of resources, and this is a fact that's presented to us by scientists. So what do we do with this from a regulatory perspective? We have to deal with this as lawyers. We have to put it in a regulatory toolbox or multiple boxes. So again, there are multiple layers of engagement with this from the perspective of commercial use in particular, but not necessarily exclusively. And when I say, again, maybe another disclaimer, when I say regulation, this doesn't have to manifest in the form of legislation. It can be policy making, it can be soft law, it can be something that helps govern and guide the way that a certain policy is pursued. So in the short term, again, we have all the research and development activities in the space resources studies. In the midterm layer, we have more development of infrastructure in line with these short-term goals. And in the long term, we will have to talk about, as we do now, on the regulatory framework on on-site operations and their governance, who owns what, and what happens when two states or two operators want to have an activity within the same place where they know there's a particular valuable natural lunar resource, for example. Depending on whether we're talking about public, private, or military somewhat of a special segment of public, one could say, the regulatory framework will ebb and flow as well. And then the somewhat of an overlap with others, but environmental impact assessment, taxation, licensing, and regulation, they're all part and parcel of the way that we deal with this abundance from a regulatory perspective. And in Luxembourg, for example, we have the 2017 law specifically on natural resources. In 2015, US passed the law, UAE, Japan, likewise, and there are a few other countries who are planning to do so. So the second one, and no one will be surprised when I say that space is an extremely risky place. Risk is also, even though it's a fact, it has to be addressed from a regulatory perspective. And we are dealing in a very risky environment, to say the least. So allocation of responsibility is something that is chiefly done by international law, but then there is a national liability allocation that is usually done through the national laws. There are requirements and regulation on insurance coverage, for example. We can obviously talk about the risk mitigation. We have now the upcoming EU law, for example, the STM rules, the Space Traffic Management Framework, that is a very hot topic right now. And certain registration requirements that help us from a regulatory perspective to alleviate and mitigate the risks associated with being in space. There are inherent risks associated with space just by the fact that space is space, but there are also human-made elements that add on top of that risk. So again, conceptualizing all this as simply a question of insurance or liability is one thing, but establishing even discursively the word environment in there helps us conceptualize and see its links with different productions of environment as well. Which brings me perhaps the most obvious production of environment, as Professor Ormerod also calls the wilderness environment, the most ethically charged, perhaps the most philosophical inquiry into what environment really is. Again, Donna's presentation really highlighted sort of what our priorities should be, and in this case, in the most traditional understanding of what environment is, the question repeatedly comes up, is there an inherent reason why we should protect outer space environments, right? Can we, maybe very provocatively, of course, some even have posed the question, can you even pollute an environment where there are no living things, which is an outrageously anthropocentric view, but it's been posed. We have, again, Niklas has mentioned already, so I won't go too much into detail, Article 9 of Outer Space Treaty, one could say is the foundational principle that really gives the states a certain sense of obligation that they have to be cognizant of outer space as wilderness, right? Not only outer space, but also Earth, vis-a-vis the activities that they conduct. And there's already some regulatory initiatives in the domestic law framework, for example, the Finnish law on space activities, the more recent Cypriot law on space activities, that have licensing requirements directly attached to environmental in the sense of wilderness in order to be able to get a particular license. We don't find that in every space law, unfortunately. Finally, and this is something that researchers from COSPAR has actually pointed out, that they said all of these nice things that you're saying, they're very commercially minded. What about research environments? And indeed, when you look at the Outer Space Treaty, scientific exploration use, it's everywhere. It's one of the most fundamental purposes of the Outer Space Treaty in the way that it's facilitating these activities. So indeed, it is an environment that is conducive to research. It is exactly that the more we know about outer space, the better we will be able to operate in outer space, and the more we will know about ourselves. So this particular production includes all types of regulation, all types of activities that concern research about and in outer space. So this includes, obviously, research conducted in orbital space stations, collection, storage, eventual scientific or even commercial applications of space-based data, research on Earth ecosystems, climate change. We also know there are a lot of commercial activities in these particular fields. The embedded AI technologies basically being augmenting the space data that we are using. Deep space observation and rules of ethics, again, a very broader reading of regulation pertaining to this particular research. And again, this science does not equal commerce, which is true, of course, but there are a lot of commercial actors, maybe some of you are in the audience, that pretty much focus on research activities primarily. And they use this scientific data in order to procure these projects and carry them forward. So some brief concluding thoughts. I have 1 minute left. So one thing that might come to mind is, yeah, but then if we sort of expand the notion of environment as broadly, everything is environment. Well, yeah, that's kind of my point. Everything should be included in this discursive list of things that it gives us a more holistic picture of what environment encapsulates and not. And it emphasizes the fact that environment is not an external consideration that we take into account in addition to all these commercial day-to-day things that we have to care about. It is part and parcel of this regulatory framework, and it can be incorporated in a very interlinked way through all these four productions. And again, emphasizing outer space as environment, in my opinion, demonstrates how, for example, risk and wilderness and research, they're all interconnected. When we talk about dark and quiet skies, we can talk about risk management, we can talk about wilderness protection, we can talk about creating a regulatory environment conducive to research. So it's not exclusive to one or the other. Finally, regulating outer space as environment, as it might be a scare word for some, does not hinder private capital and its activities. To the contrary, it elevates and facilitates commercial operations in sync with public concerns. And everything that Donna said and everything that we can say about the future of lunar governance, these are not separate considerations, that these are not independent, isolated camps, they're one and a whole. Thank you.
Thank you, Güneş, for a very interesting presentation and bringing the environment as such into the discussion. Our next speaker is Antonino Salmeri, Director of Lunar Policy Platform, and he will be presenting 10 lunar policy priorities for safe and sustainable lunar development.
Thank you, Dovile. Good afternoon, dear colleagues. It's a pleasure to be here. Thank you so much, Dovile, for having me. Thanks to the Luxembourg Space Agency for organizing this wonderful session. My name is Antonino Salmeri, and today I'm going to tell you about 10 policy priorities for safe and sustainable lunar development. Before doing that, I want to acknowledge how the Space Resources Week has advanced in promoting conversations around regulatory and legal and policy topics. I was at the very first Space Resources event in Europe that was done by ESTEC in 2018, and there we only had 2 minutes to talk about the legal and policy aspects. It was 2 minutes for me and 2 minutes for Professor Tanya Masson-Swan, and now we have a whole session, and I think this is a testament to the great work that the LSA and Dovile have done in putting together this topic together with the technical, economical, and business analysis. So this has to be an interconnected discussion. Otherwise, we will not make progress on either end. So, is it moving? Yeah, great. So today I'm going to tell you about 3 things. First, I will have to introduce you a little bit to the organization that I have the pleasure to lead, which is the Lunar Policy Platform, in order to be able to talk to you about our work for lunar policy priorities and hopefully moving into a proposal for what we call a lunar policy decalogue, which would be essentially an outline for 10 policy deliverables that we need for safety and sustainability on the moon. So what is the Lunar Policy Platform? We're a new initiative. We are an experts facilitator of lunar policy making. You have heard already today, and you might know if you're familiar with this sector, that there are a number of different initiatives and different players interested in lunar policy and space resources discussion. But so far, we are lacking not only a forum for formal coordination among member states, as Dorin presented before, but we're also lacking organizations that look at the bigger picture and that try to bridge the gap between different organizations working on this topic. So what the Lunar Policy Platform was created for that purpose, in order to be a facilitator, talking with different actors and informing them of what they have in common and what they don't have in common. For that reason, we have a global network of diverse stakeholders that support our work, but also that we generally work with in order to find common ground among them. And this includes organizations such as the LSA, as well as ESRIC, as well as civil society organizations like Secure World Foundation, for example, and expert academics that contribute to the discussion with their own perspective. Because again, we need to talk to the entire value chain in order to be able to produce that common ground that we need for more focused discussion in the international, multilateral, and domestic fora. And we do that in a politically neutral manner, and we do it not for profit. So we don't have positions of our own, we connect the positions of others, and we identify common ground amongst them. Our goal is exactly to facilitate and support global consensus as an enabler of safety and sustainability. You know that the agenda today in the space community is very packed. There are many different topics that have to be discussed. If you go to Corpus, you will see it for yourself. And so we need to be able to have more focused discussion and to understand where we can agree on. And so we do that preparatory work so that you can read some of the documents we produce, and then you can understand what is that different organizations agree or disagree with. And that could be used to facilitate and accelerate consensus. And through consensus, we can develop the deliverables we need for safety and sustainability in an adaptive approach. I think the first time the word of adaptive governance was presented, it was in 2019 at The Hague working group, and now it's becoming almost a mantra. But what does it mean to have adaptive governance? It means to produce deliverables that could be updated year after year, and for doing that, you need organizations that support that type of work, and that's why we established the Lunar Policy Platform. How do we do that? Last but not least, we produce reports, such as the one that I have here with me today, and this is the core work behind the presentation on lunar policy priorities. These reports, again, are very concise documents, around 25 pages, and they put together the perspective of different organizations, identifying those are the points in common, those are the points that are not in common, and then everyone can read these documents and understand for themselves which side do they want to take, how they can promote consensus among the different actors. We do that, obviously, with the primary goal to support the work of the UN Committee on the Peaceful Use of Outer Space and contribute to the work that UNOSA is doing on these topics. You've heard, again, previously from Dorin, there's going to be a UN conference on sustainable lunar activities. There is a proposal in Corpus for an action team. All this initiatives have to be supported through expertise, but also through actual work that could be done because of, again, of the lack of resources and also because of the very packed agenda that all these players have to deal with. And we also organize workshops for capacity building. I want to emphasize the importance of the last point. Last year, when we were discussing about lunar policy priorities with different actors, we tried to reach out to as many developing countries as we could. But almost all of them told us that they have no position on these topics because they don't have any expertise. And so we thought that something that has to be done today, and that organizations like us, but also others could do, is to bring education, is to educate these players, provide them with knowledge through dedicated workshops that could be done. And after those, then these countries can develop their own position and participate in the global discussions in a meaningful manner. And I think we got a wonderful example of that. Last year, CARI and Secure World Foundation organized something similar to that on the perspectives of emerging nations on space resources. And it was extremely helpful, I think, to produce exactly that type of awareness we need for more informed discussions. Now, going into more of the details of this presentation, last year when we started the work of the Lunar Policy Platform, we identified as the starting point the understanding of what priorities we need to address. What are the topics that we all agree have to be on the agenda in order to enable safety and sustainability? And we worked for 9 months consulting over 40 stakeholders to understand these priorities, again, across the entire value chain. So we spoke with governments as well as with industry, science, experts, and obviously also entities committed at the UN level. And the work that we have done is in this report that you can find online. I also have some copies with me here in case you are more of a hard copy person, as I am myself. And it is a condensation. It's a starting point of this agreement. It's not definitive, and it's meant to be adaptive. So every year or every 2 years, we're going to conduct these consultations again to make sure that the priorities that we have identified are still relevant, that all the actors continue to perceive these topics as important topics in order to make sure that we are focusing discussions in the right direction, or at least that we're trying to do that. And those are the 10 topics that emerge out of the consultations that we have done. We divided them in 2 groups, 5 macro areas and 5 specific topics. Among the macro areas, you've seen transparency, which I think it's the starting point of any conversation and the result of a number of years of work that we have done, for example, with the Article 11 project that, again, Luxembourg is very familiar with. Coordination is related to transparency. If there is no awareness, if we don't know what the others are doing, we cannot coordinate with them. But inclusion has to be a key part as well. Again, there cannot be a sustainable and safe development of the moon or use of resources if everyone is not at the table, and if all of the actors are not participating with the same level of knowledge. Again, if we have a disbalanced conversation, it will not bear the same fruit that if everyone is really meaningfully involved in these conversations. And then infrastructure, I think it's a key topic now again for discussion at Space Resources Week. If we want to have a sustained and sustainable presence, we need to invest in the infrastructure, but the infrastructure also poses some policy and legal question about how do we make sure that this infrastructure complies with the principle of free access to all areas of celestial bodies, and how do we make sure that we can share potentially this infrastructure through interoperability. And frameworks are the final topic. We need to have a systemic approach to these conversations. If each of us goes into one direction without a common understanding, again, of what the others want to do and what the others have in mind, then we will go in a divergency that ultimately will threaten, again, safety and sustainability. And specifically on topics of interest that have to be developed more urgently, you see at the top of the list is always landing, which is one of the most disruptive activities you can do on the moon because of the effects on the lunar environment, which is the second topic. I think today we have to understand that the lunar environment is not just a question of what can we do in the environment, but what the environment can constitute a threat to other activities. And so by engaging in responsible activities on the moon, we can start a chain of events that may prejudice others for the activities that they want to do, and we may not even be aware of what consequences we might start. And therefore, studying the lunar environment, having a proactive approach to what are the unintended consequences on our action is not just a question of interference, it's a question of how do we relate with the environment. And this is also obviously a primary concern for science. As you know, science is one of the main drivers for lunar activities, and it's a driver that has to be, in a certain way, taken into account when these activities are planned. I don't want to use the word protected or preserved because it implies a sort of judgment of value, whether something is more important than something else. At the same time, the interests of science are there because the moon is a pristine environment. If we contaminate it, we may lose some of the scientific opportunities we have. So we need to be mindful of our consequences on the environment to make sure that science can be meaningfully conducted. Resources are obviously related to that. The use of resources is fundamental for sustainability. I don't need to repeat that. I think it's becoming very clear every Space Resources Week that we address. And then frequencies. Again, I remember when we were in the Hague Space Resources Working Group, the discussion around frequencies was perceived to be really too far away in the future. I remember the working group wanted to recommend the ITU to consider this topic. This was 2019. And then everyone was saying it's too early. And now finally at WRC 2023, now there is an agenda item, a study group. And so things are moving forward. But without frequencies, no activities can take place on the moon. And so we need to work together with the ITU to make sure that those frequencies are allocated in compliance with the procedures already exist and with the mechanisms that are there. There is no need to reinvent the wheel on that. Now, having identified the priorities, the next question becomes, what do we do in these priority areas? What kind of tools do we need to develop? And so based on the conversations that we had with our stakeholders to produce the policy priorities, we took a stab at a first beginning. And so we developed something that we call the Lunar Policy Decalogue, which is an initial proposal of 10 policy deliverables that are needed for safety and sustainability. This list is pretty much tentative, so we are looking forward to hearing your comments. If you think that some of these deliverables are not needed, or if you think that we are missing some of the deliverables that are needed, talk to us. Again, this is not written in stone. The goal is to foster adaptive governance by proposing something, iterating on it, experimenting on it, and then repeating it until we have reached the point that we can solidify this in a more, let's say, stable way, for example, through international agreements in the United Nations Committee on the Peaceful Use of Outer Space. But we don't want to make the mistake of formalizing rules or procedures or processes that we're not sure that they are the right ones. But we still need to begin at this process. And that's why adaptive governance means admitting that we don't have all the answers today and that we need to try with something, repeat, iterate, do it intentionally until we reach to the point that we are satisfied. And so the Lunar Policy Decalogue proposal is meant to do exactly that. So in conclusion, and not to take too much of your time, I want to emphasize that today, if we want to have effective discussions and impactful discussions on space resources as well as lunar governance, we need to talk to each other, but that's difficult. And that's why having an organization like LPP supports that. We do it in a professional manner, and our goal is to facilitate consensus so that other bodies can take the decisions they need to take in an informed and inclusive manner. to start this work, we produce a priorities report. It's the first time that you see 10 areas explicitly addressed as being important, not more important than the others, but let's say more urgent, and that you see organizations standing behind them. Again, not taking any formal commitment towards them, but understanding that this is something they all have in common, and that they can use that for further development and focused discussion. And in order to do that, we invite you to engage also with our proposal for a policy decalogue, which would hopefully support the development of targeted deliverables that we need for safety and sustainability, so that we can use the moon for the benefit of all countries and always say all humankind, present and future. Thank you very much.
Thank you, Antonino. Antonino's work is a wonderful example of what can be achieved by such organizations as LPP, and how useful it is also for all the work and discussion at UN Corpus. Our next speaker is Jean-Louis Schiltz. Monsieur Schiltz is a partner at Schiltz & Schiltz. He's a legal advisor, professor at the University of Luxembourg, and a former cabinet minister. The floor is yours.
Thank you very much, Dovile. I'm actually, as you said, a professor at Luxembourg University, dealing with all sorts of laws that relate to technology. But I'm first and foremost one of the authors of the Luxembourg Law of 2017 on space resources. And rather than giving you a sort of a technical lecture about what this law says, I want to concentrate, although I have the technical slides with me, and the organizers, I'm sure, will share them with you. I wanted to give you a little bit of the background that led to the elaboration of the law. When in the winter 2015 and 2016, Minister Schneider, who is the father of space resources in Luxembourg, as all of you know, approached me and asked me whether I would want and be in a position to help him on drafting Luxembourg space resources law. My first answer was to say, well, I know nothing about the legal system related to space resources. And he said, well, you know, this is not unusual, because the only legislator that is seriously working on this and is about or just has enacted a piece of legislation on this is the US. And he went on telling me, well, you're familiar with telecommunication regulation, you're familiar with media regulation, and first and foremost, you're familiar with the regulation of satellite business. And satellite business, in terms of space and outer space, is just as close as you can get to the outer space. So please go ahead and draft something. The other unique piece of the setting was that Luxembourg at the time didn't have a space law. So we basically did it the other way around. We first had a space resources law and then only had a space law, which was enacted 2 or 3 years later. And the main challenge, and that's my third general comment, third and last general comment, was how to make sure that the legal provision, which is now Article 1 of the law, is drafted in such a way that the actors have sufficient guarantees that they actually own what they harvest in space, to put it in simple terms. And we couldn't actually draw on the US example because the legal system there is different, because we are a civil code country, as you know, and the US is a common law country, and the US text says, speaks about own, possess, use, transport, etc. And that didn't fit the European framework. So the French text actually speaks about space resources being susceptibles d'appropriation. So far as I'm concerned, this should be translated by are capable of being appropriated, although I believe that those who have done the official translation didn't take up my suggestion this time and are using the word own, which is the word that comes as closest to the French appropriation. Anyway, I think that the framework has achieved a number of objectives, and I'm going to go very quickly through the various slides of my presentation. When we presented the law the first time, we tried to convey, or the government at the time tried to convey, a certain number of key messages which I tried to incorporate in the text we then drafted. First of all, it was about providing the investors with a secure framework, guarantee the right to appropriation, which I already mentioned, and support investment and growth in that context, and first and foremost, make a European hub for the exploration and use of space resources out of Luxembourg. And there was probably no mistake at the time, because Jean-Jacques Dorin, the former head of ESA, actually commended the Luxembourg initiative a few days later. When you look at the official presentation of the law, there's a number of strategic aspects that relate to the elaboration of the text. First of all, the government made it very clear that it politically supported the initiative and that it supported private initiatives in that context, that its objectives were to put in place an attractive framework to promote research, to have research activities located in Luxembourg, and last not least, and the initiatives have been taken off in the meantime as well in Luxembourg, support also the sector with appropriate public funding. We presented the law in the fall of 2016, which is ages ago, and the comments, main aspects at the time, in addition to the strategic objective, were that, as I said on 2 occasions already, the rights of those that are extracting the resources are being guaranteed. Luxembourg was the first European country moving into that direction, and the law was aimed at being an innovative piece of legislation. It was enacted 1 year later by the Luxembourg Parliament, which is very quickly by Luxembourg standards, so less than a year. It was widely commented at the time in the international and national press as well. Luxembourg was the first mover in that context. I'm not going to go through the various aspects of the law. I'm just going to highlight a few aspects, and I'm sure the organizer will share the presentation. In my opinion, it's a law of the 21st century. It has 18 articles, which is pretty short and which is pretty old civil code style, unlike what we see with the AI Act, for example, where the European Parliament has proposed 771 amendments. Someone told me a couple of months ago that in the last 3 years, the European Commission had presented 50,000 pages of legislative text. So we got away with 18 articles in the old style of the Code Civil. The law aims at providing predictability, and the law aims at providing a stable framework. That's also why it hasn't been changed since 2017, and it aims also at supporting investments and innovation. I'm not going to go through the provisions. So again, space reserves are capable of being appropriated. You need an authorization to carry out a mission. There's a supervision mechanism by the government, which is the case in all regulatory ventures. And the operator is liable, responsible for the damage caused at the occasion of the mission. There's a number of duties and obligations in that context in the law. I'm not going to go into the details. Company has to be set up in Luxembourg, obviously mission program Luxembourg-based central administration, a robust scheme of financial, technical, and statutory procedures and arrangements. All this is pretty standard for those of you who are familiar with the setting up of regulatory schemes in various sectors, be it the banking sector, be it the telecom sector, or any other sector. By the way, the law is largely inspired when it comes to the technical aspects by the laws that govern the financial sector. Shareholders and managers need to be of good repute. Shareholders obviously have to be financially sound. That goes without saying, so I'm not going to go into the details here either. A risk assessment needs to be carried out. There needs to be appropriate coverage in terms of financial means or an insurance policy, etc., a number of financial conditions also. The authorization will describe how the mission will be carried out. I'm not going to go into the details either here, and obviously there's a regime of continuous supervision for which the ministers in charge, namely the Minister of Economy and the Minister of Finance, are in charge. The authorization can be withdrawn, and all in all, the Luxembourg law, and this is first point of my conclusion already, is a specific law on space resources, which I think you need, because otherwise you don't have legal certainty. It's a clear legal framework. It's complete, but it's light and it's short, and it has only a few provisions, and the mechanics are described also, in my opinion at least, in a very clear way. There were not many amendments during the parliamentary process of the law. So the law can also serve as an example for future legislations of other countries, and it aims at being part of an international framework of similar law and also of a number of international regulations to come. Recently, an op-ed in the FT has compared the Cold War space race to what is going to happen in AI, and has shown that what has happened in the space area, namely cooperation, be it at a very low level, needs to form the basis for all ventures that are global ventures such as AI, and they call on the AI actors to rely on the example of the space race that took place years ago against the background of the UN Outer Space Treaty. Finally, and that's the second point of my conclusion, it goes without saying that joint international efforts are paramount here: consultation with other nations, collaboration with all stakeholders, and last not least, sustainable initiatives. All in all, I think that the Luxembourg framework fits well into the international framework which is about to be elaborated, and which, as far as I understand, Luxembourg continues to advocate in favor. Thank you very much.
Thank you, Jean-Louis. I take a note on the translation issue. Our next speaker is So-Young Chung, Senior Researcher at Strategy and Planning Directorate at Korea Aerospace Research Institute. Thank you, So-Young, for coming from so far away, finding some time, so I hope it's not too hard because of jet lag. The floor is yours. You okay? Thank you.
So thank you for the introduction, Dovile. I am So-Young Chung, and I work at KARI, which is Korea's R&D Institute for Space and Aeronautics. So part of my job is to support my government on policy, strategy, and international cooperation on space exploration, including matters related to space resources. And the title of my presentation is says Emerging Space Agencies' Perspective on Space Resources Activities, but I think I need to make a few disclaimers about that before I start. First, I'm not a lawyer, unlike many of the other speakers in the room, so I won't be really talking about the legal issues. And second, I do not represent all the emerging space agencies, obviously, and I can only speak for one country, South Korea, which is becoming a new actor in space resources. And third, South Korea is about to have a new space agency in May. So my institute, which kind of acted as a quasi-space agency until now, will not be calling ourselves space agency anymore, and we will be placed under this new space agency. So that said, I'll be talking about the experiences and challenges that emerging space agencies often face when we try to engage in space resources activities. Did we go to the next slide? Ah, okay, thank you. So I want to start out by saying that new countries are becoming actors in space resources, and that's because we all want to be involved and not be left out on this endeavor. Of course, not every country may have the resources and the capabilities to directly engage in space missions, but some of us who were not traditionally involved in space exploration are increasingly becoming engaged in this endeavor and giving serious considerations to join space resources activities. So if I could give you an example of South Korea, South Korea developed and launched our first lunar orbiter, KPLO, in 2022. And it has been operating around the moon for more than a year now. So this spacecraft has 6 instruments on board, and those of you in the space resources community may already know that it hosted a NASA payload called ShadowCam. This is a highly sensitive optical camera that can see through the permanently shadowed regions of the moon, where ice water is believed to be present. So the image on the right is a mosaic image of the Shackleton crater created using the images from the NASA's Lunar Reconnaissance Orbiter, which has been operating around the moon since 2009, and the newly obtained images from this ShadowCam. It shows how ShadowCam allows you to see inside the dark craters, which you couldn't see before. So South Korea already has an ongoing lunar mission with direct link to space resources, and we plan to do more with a follow-up mission, which is the lunar landing mission expected for launch in 2032. So while the specific instrument for this mission will be determined at a later stage, this mission will include a component of ISRU tech demo. So Korea's case is a good example of how the new countries are joining and becoming real actors in space exploration and how they could potentially be engaged in space resources activities in the coming future. And of course, Korea is not the only one. These are the examples of some other countries with plans for lunar missions. I only listed a few from those who took part in the space resources workshop that was held in Korea a few months ago, which is already mentioned. So top left is Australia. They have a strength in mining and automation, and they are working on a rover to collect and deliver regolith to a NASA equipment that will extract oxygen and oxygen from regolith. And top right is Brazil, and they're working on a lunar orbiter to observe near-surface plasma environment of the moon. And Brazil has strength in agriculture and farming, and they also formed a group to study space farming together with a state-owned research corporate dedicated to architecture. And bottom left is Turkey. They are working on a 2-stage lunar program. The first mission is an orbiter, and it will be hard landing on the moon. The second is a lander and rover mission, and some of the instruments on board these missions will also be related to space resources. And bottom right is Mexico. They had micro rovers on board the Astrobotics' first US commercial lunar lander, which unfortunately did not succeed. And I also know that there was a Mexican company working on developing some ISRU technology. And at this point, I want to ask you, how many of these plans or missions were you aware of before? And how many other planned missions or efforts from other smaller or new entrant countries that were not traditionally involved in space exploration were you aware of? Now, not every plan or efforts undertaken by these new countries will not be successful, nor will the scope or the depth of their involvement in space resources activities match that of the established or large space programs. But what I want to say here is that those of us who are new will be there when we go to the moon and explore space resources, and that our presence will matter. So space resources are bringing a lot of opportunities, but also challenges to the newcomer states. to space exploration. And once again, let me give you some Korean experience as an example. Sorry. So in Korea, our political leader made a commitment to Korea's long-term engagement in space exploration, and exploration and use of space resources became a critical component of our future space program. And policy decisions in that regard have already been spelled out in strategic documents and national plans for space activities, as well as the recent law to establish the National Space Agency. To give you some more details, the Space Economy Roadmap, which was announced in November 2022, stated that Korea will begin lunar resource activities within a decade, so we could give the future generations the resources of the moon. The updated space promotion basic plan released in December 2022 included plans for Korea's lunar landing and Martian landing, and emphasized Korea's participation in international exploration initiatives and development of ISRU technology. Finally, the recent act for establishing the National Space Agency, which will be called the Korea Aerospace Administration, KASA, prescribes that this new agency, among other things, will be responsible for matters related to exploration and use of space resources. So this brings both opportunities and challenges to us, because politicians can only tell you what should be achieved, but not how it can be achieved. And often it's up to the space agencies or the technical research institutes to determine whether such goals can be achieved with the available resources or the capability that you have, or within the existing regulatory framework. Now, in Korea, politicians are not the only ones that are interested in on this topic. A recent survey on the public perception of space has revealed that the Korean public has exceptionally high interest and expectations for space resources. When they were asked of their opinion on which areas of space within the space sector will become important in the future, more than 27% of the respondents chose space resources as the first choice. And this public perception held by the Korean public was not something that was promoted by the government or any prominent figure. I think this naturally grew out from this long-held notion that South Korea is a resource-poor country. And that notion resonated well with our public when they heard the word space resources, and makes them eager for their country to go after the natural resources that are out there in space in abundance without national boundaries. So in addition to this, I think to some extent the media also played a role. A movie depicting a competitive race between nations for space resources on the moon, or an article about the enormous value of helium-3 or plutonium back to Earth has created some hype around space resources among the general public in Korea. And this again brings both opportunities and challenges. From the political perspective, one could say that having public support for space resources is great, but if such public support and perception is not well grounded in reality, this could become a risk. And communicating with the public based on facts isn't always easy, especially if you don't have enough expertise on the subject matter to explain to the public. And another group within Korea that has a lot of interest on the topic of space resources is scientific and technical community that wants to carry out related R&D activities. And currently we have 4 main entities that are engaged in space resources or ISRU-related technology development. And my institute, KARI, has interest in and expertise in developing space systems. And we're interested in utilizing ISRU for exploration purposes for long run. And KIGAM, Korea Institute for Geoscience and Mineral Resources, established a Space Resources Center last year, and they have an extensive knowledge in geology and mineralogy for Earth, and expanding their research interest into space. And KICT is a civil engineering research institute. They're interested in space constructions. And Hyundai Automobile, some of the people from there are sitting in this room, and I think you know this company, and they're interested in surface mobility, and they're working on a lunar rover that can be used probably for space resources activities as well. So this again represents both challenges and opportunity to us. It's nice that many actors are interested in space resources and ISRU, but they all have different interests and priorities. And we found that bringing these different actors together to coordinate their activities at the national level is not easy because they all come from different sectors and haven't really worked together before. Now, international engagement is another aspect that I want to emphasize. There are various multilateral international forums that you can take part as a space agency. In terms of coordination in space exploration activities, Korea take part in the International Space Exploration Coordination Group, ISECG, and we also have been participating in NASA's Moon to Mars workshop. And we're trying to find an opportunity to work with NASA on Moon to Mars. And in terms of coordinating in legal and political matters, Korea is a member of our Artemis Accords, and we take part in the Artemis Accords Signatories Working Group. And Korea is also a member of COPOS, and we take part in various discussions there, including the Space Resources Working Group. And availability of these different forums bring new opportunities, obviously, for partnership, but having to follow different discussions and to coordinate national positions at different forums is also a challenge, especially because in smaller agencies, you don't really have enough number of staff or people with the right background to deal with all these different initiatives. For example, myself have to cover all of these activities. They're listed here, and we really don't have enough people to deal with all these important issues. So here are some common challenges or questions which I believe that the new entrants are often faced to answer. How do you determine your national priorities and interest in space resources? How can you establish successful partnership among various actors, both at domestical and international levels? And how do you determine your national positions on regulatory and legal aspects of space resources activities? And when Korea had to answer these questions, our answer was, we really do not know the answer. So we needed to do more study. There were two things that we organized, and first was the international workshop that was mentioned before. Since we don't have much time, I'll just skip this. And the second was, second initiative that we took on was at the domestic level was to organize a study group to determine national position on legal aspects of space resources. And this is an ongoing effort, and so we had to bring together a multidisciplinary group of experts with various backgrounds, some with backgrounds in different types of law, some with backgrounds in political science, international relations, scientists and engineers. They're involved in related research, and policy people like me. We all sat together to start looking at this topic since last year. And it's really not easy for us to talk to each other because we all speak different languages and we don't have the basic knowledge that other people have. So, but it's been a great experience, and we feel like we are building a new community and which will last and evolve and make important decisions for Korea's future in space resources. So engaging in a topic like space resources is really challenging, and you need to build a whole new community of experts to deal with issues that arise from these new activities. So this is my last slide. So I want to conclude by emphasizing the role of space agencies in shaping the international legal framework. The role of space agencies are really important, especially in smaller or new entrant space agencies, because they're often the only actor that can implement space exploration missions and space resources activities at the national level. But even with private actors involved, they often act as a promoter of commercial activities or act as customer of commercial services. And space agencies act as partners in international cooperations and collaboration as well. And last but most important, when it comes to shaping the international legal frameworks for space resources, they provide expert knowledge to inform government policy making, especially so if you don't have a well-established space program. So it's very likely that the space agencies or the experts that work for them will form the core of the epistemic community that will enable the formation and coordination of the international framework for space resources. And they're also likely to become the core practitioners of this new framework that might be established. And if that international framework really wants to become successful, they should make sure that they involve all the people, all the experts from around different countries, especially those who work at the space agency. So with that, I would conclude my presentation. Thank you.
Thank you, Soyoung. I actually have a question for you. So I imagine that now you work on the future national legal framework for those activities. Do I understand correctly? Do you have like a timeline? Will it be like a separate law or something more general? I would appreciate if you could share any details. I understand that it might be too early.
Right. We don't have any timeline yet, but within our national plan, we are required to consider the legal framework, new legal framework, including something that applies to space resources.
Thank you, Soyoung. So I would like to introduce our last speaker, Yu, First Secretary, Department of Treaty and Law, Foreign Ministry of China. And Shu will be speaking about how to bridge the gap between Outer Space Treaty and the future international framework for space resources activities. The floor is yours, Shu.
Thank you, Dovi. Today, my presentation is about how to bridge the gap between Outer Space Treaty and the future international framework for space resources activities. In trying to formulate an international framework for space resources activities, we at first should start from the existing space laws. Among them, the Outer Space Treaty 1967 is often the primary source we start with. At the first ever space law treaty born under the shadow of Cold War, with two superpowers' blessing, Outer Space Treaty has been exploited by generations of space lawyers and policymakers with great relish. In the coming decade, various space resources activities will open a new episode to explore new perspectives and alternative ideas on Outer Space Treaty. Indeed, the legendary treaty will return. So in broad brush terms, currently there are two approaches to factor Outer Space Treaty in the design of a future international framework. On the one side, people focus on its key provisions, such as non-appropriation, and paint Outer Space Treaty heavily as part of the problem, posing an insurmountable obstacle to the future international framework. On the other side, the Outer Space Treaty is regarded as a bunch of very weak principles, which either lack specificity to regulate space resources activity, or the compatibility with the future international framework be presumed and not subject to further scrutiny. Although I sympathize with them, I disagree. Outer Space Treaty, in my humble opinion, is part of the solution rather than part of the problem. Its real strength lies in its general nature, and its vast potential, once harnessed, would help overcome the mounting challenges, deliver certainty and opportunity, and in turn, future-proof the international framework for space resources activities. Then the pressing question is how to bridge the gap between Outer Space Treaty and future international framework for space resources activities. Firstly, I see the answer in consistent interpretation and application of Outer Space Treaty. This treaty, in its Article 1, defines the exploration and use of outer space and the province of all mankind. Looking to the future, a slew of new activities aimed at harvesting space resources clearly fall within this scope, and the safe and orderly development is in the common interest of the international community and beyond concerns of specific countries and companies conducting such activities. In addition to uplifting the status of space resources activities, the Outer Space Treaty also provide foundational norms and principles that are tried and tested, and therefore can be adapted for an effective international framework. The adaptation, however, would not be easy and might go wrong for various reasons. Therefore, agreement on the meaning of outer space provisions, as well as the purpose for their application, should be prioritized by the wide international space community, including commercial and other new space actors. Treaty provision interpretation at both science and art have different facets and employ multiple rules. How to apply those rules to ascertain the meaning of specific provisions of outer space treaty is itself a daunting task. Furthermore, I would caution against missing the forest for the trees in the process. Articles of outer space treaty cannot be applied mechanically and separately from each other. While the text of the treaty need to be broken down for the purpose of interpretation, they ultimately ought to be put back together in order for each provision to function. For example, to interpret and apply Article 2 of Outer Space Treaty and the non-appropriation principle embodied therein, we need to refer to other articles, including those related to the freedom of exploration and use of outer space, international cooperation, and benefit for all mankind. Therefore, as to whether certain space activities for mining space resources is compatible with the non-preparation principle, I'm afraid we do not have a clear, straightforward answer. It all depends. Since the answer offered by the treaty interpretation is context sensitive, my second advice to fill the gap is to improve the implementation of Outer Space Treaty. Article 6 of Outer Space Treaty requires states to authorize and continue to supervise space activities carried out by their entity. To assure the implementation of the treaty provisions and impose international responsibility on states for that purpose. Comparing with rocket launching, satellite operation, and other traditional space activities, mining space resources will entail a full spectrum of new space operations, many of which are not envisaged by the Outer Space Treaty. It is out of question that this article, that is Article 6 of Outer Space Treaty, is applicable to space resources activities. But how states implement it over various modalities of space resources activity remains unknown. Truly, it remains a state's prerogative to manage its national mechanism of authorization and supervision, as long as it fulfills its international obligation under the Outer Space Treaty. But at the same time, we increasingly see the value of sharing information among states on the implementation of Outer Space Treaty, as no national mechanism is entire of itself, and the future international framework asks for fair and equal opportunities at a level playing field across national borders. Besides laws, regulations, and policies government authorities adopt for implementing Outer Space Treaty, an important missing piece of the puzzle is the practice of commercial space actors. The implementation of Outer Space Treaty should be a dynamic, vibrant ecosystems which require the players on the ground, including those startups aspiring for space resources activities, to translate laws, regulations, and policies into the internal rules, bylaws, and daily work. The feedback also will contribute to reviewing and further improving the national laws and regulations, and to better address their needs in the implementation of Outer Space Treaty. Furthermore, their practices will become an evidence base of state practices in implementing Outer Space Treaty, which in turn will assist the interpretation of relevant treaty provisions. Consistent interpretation and robust implementation are the two heaviest building blocks of my Outer Space Treaty bridge, but they are not enough. My third and last advice is that international cooperation and coordination in this field must be institutionalized. International cooperation, as reflected in the preamble and several articles of Outer Space Treaty, is a gene of all human space endeavor. Many landmark space programs could not succeed without international cooperation and mutual assistance. As space resources technology and engineering are not yet mature, care must be taken not to establish too rigid framework, which might hinder scientific research and technology development. This would render international cooperation and coordination even more critical. International cooperation can take different forms and serve different purposes. I would suggest a pragmatic approach and establishing an inclusive platform to promote dialogue and coordination among space resources actors. The Artemis program at International Lunar Research Station as a leading deep space projects also can lend their experience and support to the future international framework on space resources activities. As far as the Lunar Research Station is concerned, international cooperation should go beyond the specific project and create opportunities to contribute to and benefit from for the wide international space communities, including industry, academia, and the general public. Such requirement applies equally to space resources activities and need to be taken into account in building the future international framework. With that, I conclude my presentation, and thank you for your attention.
I would like to thank all speakers for their complementary views, very unique positions, and for giving us so much food for thought. Unfortunately, we run out of time for our discussion today. I would like to invite you all to enjoy the remaining coffee break at the foyer on the ground floor. So thank you very much for being with us today. Have a nice afternoon.